the second session. The issue in the second session is parliamentary supremacy or judicial overreach. Now, since inception, we have seen the results of the judicial review, whether it's Keshwananda Bharati, Privy Purse, and many more cases. As we have adopted this from the United States Constitution. And later on, in the mid-1970s, judicial activism, where we have seen many judgments by Justice Krishna Iyer, Justice Bhagwati, where concept of due process of law evolved. Now we are in a new phase where we are discussing judicial overreach, where we are seeing situation during the arguments in courts, where we have raised the issue of whether courts are entering into the domain of lawmaking or whether by precedents the direction is towards amend the law which is within the domain of legislature. Now to start this, I would like to start with Sri Vikramjit. Sir, would like to be the officer of the court and also being a learned ASG, want to know that in the present scenario, we have seen the 6 cases and in the NJSC also, where issue of supremacy of the parliament or the judicial intervention in the lawmaking process of the parliament, where the law which is passed by the parliament has been struck down by the Honorable Supreme Court. So whether this can be seen as a conflict or being the guardian of the Constitution or to protect the rights of the citizen, the judiciary can enter into this domain, this arena. So I would like to start with this comment.
Thank you. I'm not speaking strictly as a law officer, because then I hold forth the views of the government. I'm speaking about what I think is relevant to discuss this topic, and I'll just flag mark 2 broad issues. One is in context of India. I think we have to appreciate this, that in India, when we framed our constitution, for better or for worse, we chose the Westminster form of government. We could have, at that point of time, various models were available, including Indic models suggested by Mahatma Gandhi himself. But we specifically chose a Westminster form of government. And that Westminster form of government is distinct from a better word, the Washingtonian form of government, which mixes, the Washingtonian government mixes presidential powers, very strict separation of powers, while the Westminster form of government specifically includes Parliament above all, because it believes that it's the Parliament which takes decision on behalf of the people, and the role of the judiciary is to test parliamentary legislation on the question as to whether, in our case, it would go against the Constitution. So it has a limited role. In Britain, at one point of time, there were not even fundamental rights. Fundamental rights was later incorporated into the constitutional law of Britain, because Britain doesn't have a written constitution, based on the fact by incorporating the European Charter, which is still greatly debated today. So the very crux is the role of the judiciary in a Westminster form of government is limited. The tendency to Americanize our constitution by reading strict silos and separation of powers, which is what the NJAC government spoke about, to me is contrary to the Constitution. If all of you are interested, I would suggest that you look at a YouTube video of a former UK Chief Justice of the Supreme Court, Brenda Hale, where she spoke about, very interestingly, about why it is not necessarily bad that all organs of the government, whether it be executive, legislative, or judiciary, work together for a common purpose and are not at each other's throats all the time, which is the hallmark of the Washingtonian government, which believes that, these parts of the government are constantly opposed to each other, and there should be some sort of supremacy of one or the other. The Westminster form of government clearly envisages that there is a dominance of Parliament and there is a specific role to be played by the judiciary. That's on the Indian context. That's the first point. The second question as to judicial overreach, and this is my controversial take, this is not only an India issue. This is now increasingly a globalized issue, whether it be playing out in Israel, whether it be even playing out in the UK, whether it be even playing out in Australia. The question which squarely falls is this. It seems that over the last 30 years, there have been weaker governments throughout the world. As a result, questions which usually would have been discussed and decisions arrived at through the public process of discussion and democracy have been taken out of that public space and shifted and ring-fenced into decisions or a decision-making process constituting maybe a technocratic elite, which constitutes people both from people who are interested in it and people who benefit out of it. The rhetoric is always social justice based, but the impact of it is increase of technocracy and increase of the interests of technocracy. So this conflict which you see playing out today, even in India, where are certain groups who will talk about judicial primacy, are usually wanting to reflect their values disguised as social justice through and for the purposes of maybe for business interests, maybe for social interests, but which reflect the values of a technocratic elite. We have to guard against that.
Thank you, sir. Now I would like to talk on an issue which always arises in relation to the parliamentary supremacy and the judiciary overreach regarding the will of the people. People sitting in the parliament are the people who are elected representatives of the citizens of this country. What is the mood of the nation? What people want? What law they want in the country? It is better known to the people who are in the power, who are in the center. Now when judges or the judiciary passes a law having the view that we are not coping up with the difference or the gap which has come in view of the changes in the society, can that be allowed in the form of judicial precedents or the orders passed by the courts to fill that gap? The changes which is happening in the society, like we have seen in the current scenario, where in same-sex cases, there is no law and there are so many contraventions amongst different statutes. So is it okay for the courts to interpret in a manner so that it suits to the social changes?
Thanks, Vishnukant. Good evening, friends, and my respected seniors. I fully agree with the learned ASG, Mr. Banerjee, that our constitution has been largely influenced by the Western concepts of the constitutions. So when our constitution was being framed back in 1947, the Constituent Assembly examined the constitutions world over, and they came across examples mainly from the UK, US, and other countries. This law of this aspect of judicial overreach, which we are experiencing at its peak today, as I would say, hopefully things will not further peak, and there would be a more humble discussion on this, and we would be able to find a way, a middle path. But this issue has been there in the Western constitutional arena since 1800. So that is when their first US case of judicial review took place, when their president tried to appoint some judges in the federal court. The Marbury case, it's a very famous case, the first case of judicial review, where they said that they can actually interpret the Constitution. So the act of interpreting the Constitution has been historical. And this conflict, as we call it a conflict, has been existing all over the world for over 200 years, and we find several judgments. It's just that now it is hitting us as an aware citizen of the country, and we understand that the political will is being suppressed. Now, if we really look at it, the parliament has power to legislate, the courts, the judiciary has the power to interpret the statutes, interpret the constitution. So these two powers have been there. Now what is happening is that we are restraining the political policy making and putting certain bars on what legislation can be brought and what can't be brought. So major political decisions, major political policies which are taken by the majority government, by the government in the country, that is being suppressed, and that is where we feel that maybe it is not right. Maybe it comes in the definition of judicial overreach. But there is a solution there. And in fact, if we look at it, the solution also lies in the Western constitutional history and how they have dealt with it. So we can also actually come across and go one step beyond to say and to hold. So our systems of analysis can be now more mature to say that yes, you can interpret the constitutional aspects, you can interpret the statutes, but you cannot interpret political policy decisions. Now, this is the arena which needs to be understood in the judicial arena, where we say that once a statute has come, it can be examined in view of the Constitution. However, where a political decision, a political policy decision has come, to what extent the court can hold, the judiciary can go and say that this is a wrong policy decision. So we, as I was saying, we do have examples in the West where the courts have held, despite holding the power of judicial review, they have also held that in political matters, the constitutional courts cannot intervene. And that is where we need to put a more mature understanding of the legal provisions, if I can submit like that.
Thank you, ma'am. As we have seen, we have always talked about the check and balances, that there is no stringent division of separation of powers. Like in US and Australia, we have directive principles, we have by judicial precedents, like under Article 13, 26, 32. by invoking those powers, judiciary has passed judgments which have effects, which has at we can say that they are in a way they become law of the land, but they are have a substantial effect on their implementation. So how this thin line where a judicial activism or judicial review becomes judicial overreach, how that can be restrained or how that can be assessed that this is now this is the Lakshman Rekha. Now, if we go beyond this, we are stepping into the area of legislature.
So I will now, you finish the question? Yes. This is a topic which has no beginning, it has no end, as we were just now discussing. And therefore, I would just want to start with a word of caution. Let us not just go by what is happening today and come to a judgment. Let us please start thinking from the time of Shankari Prasad, Sajjan Singh, Golaknath, and then come to Keshavnand Bharti. Please be aware, and I'm sure most of the people present here know, that in the Keshavnand Bharti case, despite giving the basic structure doctrine, most of the amendments, the 24th, 25th, and 29th amendments, were upheld by the court. Thereafter, let us not forget the emergency and the Indira Gandhi versus Raj Narayan case. Then let us move over to the 42nd amendment, which was struck down in the Minerva Mills case. Can we today say that we don't want all this? Who is going to take care of filling up the gaps? One case or today one government cannot decide this entire issue for us in our minds. We have to see, and when my learned friends were speaking, it was floating around in my mind that we do not actually have a strict separation of powers like the Montesquieu model. So therefore, this tussle continuously happens. It's a vibrant democracy. We need this tussle. We don't want a pliant judiciary. These are the boundaries that the parliament and the judiciary, they have to push. There will be a tussle, but that is what is good for the citizen. The constitution is supreme. The rule of law is supreme. And our courts will decide according to the rule of law. They will decide according to what is best for the citizen, what is actually needed in a welfare state. So to today say, based on any one matter, I would say that we should be careful about it. There might be views on both sides, but ultimately, this balance, this filling up of the gaps is what is actually required. I would say that we also have to view the difference between judicial overreach and judicial activism. They're two very different things. Judicial overreach is a term which comes in when the parliament feels that the judiciary has come up with a judgment, it has to now come up with some amendment and to do away with that. Now that, I think, is something where we need the balance to be carved out. And that balance has been going on in our country since 1951. If you can recall, Justice Modholkar, in the Sajjan Singh case in his dissent, had actually talked about basic structure being protected. Since then, it took then the 11 judges in the Golaknath case to actually stamp that particular doctrine. When Keshavnand Bharti came, it actually overruled Golaknath case because it went on to actually decide largely in favor of the government, but protected basic structure, which was very important. When emergency came, I'm sure many of you would be aware over here, then there was an attempt for the review of the Keshavnand Bharti case. Mr. Nani Palkhiwala appeared that time, and there was confusion in the court as to who had actually filed this review. Because everybody said one state, the other state, Gujarat said, Tamil Nadu said, no, but we have not filed a review. Finally, one by one, the judges then decided to dissent, and finally, the case was closed, that review was closed, which is very good for us today, because the basic structure remained intact. Thereafter, Article 368, because of the power of Article 368, and if you would remember, Justice Chandrachud's judgment later saying that if limited power of amendment has been given under the Constitution to the Parliament, it does not mean that the Parliament will use that limited power to expand its power of amendment and to say that it will not fall within the laws of Article 13. And that's how the 42nd Amendment, which stopped that kind of judicial review of constitutional amendments, was struck down. So today, can we say that we don't need all this? Later on, now today we know when the privacy judgment came, then at that stage, ADM Jabalpur now has been now overruled. These are all important facets. We don't have to forget all these facets because of one case here or one case there. Today we have one government, tomorrow we might have another government, but the Constitution will remain supreme, and the Constitution gives the power to the executive, to the legislature, and to the judiciary. And this rule of law that comes from the Constitution is what our courts protect and which our parliament also legislates upon. And ultimately, the benefit goes to the citizen. And it is not the citizen represented by a person in parliament as the majority, but even the weakest of citizens. That is the protection that a constitution offers. And therefore, I feel that this tussle, this kind of balance of power, this shows a thriving, vibrant democracy, and we should be pleased that this is the situation in our country. This is what we need. This is what our protection is today.
Thank you, ma'am. Sir, I have a question. Is it possible that instead of settling the role of the courts and the judiciary of settling the dispute between the parties, by judicial overreach, they are trying to, or they want to address the issue where government is not comfortable, or where, because of the social change, it is not proper at the stage.
Yeah.
It is not proper at this stage or that relevant time to make a law to address the concern.
Okay. It's a tricky question. I think that's the question. That's the last point I alluded to when I spoke, when I said that we have to be careful that the values of a technocratic elite is not imposed on the rest of the country. The tendency of, for the want of a better word, and I'm not casting aspersions on anything, but the judiciary consists of largely people like us who are in some ways, from better or some less, Western educated, or have some sort of a values which reflect Westernized values. As a result, maybe, have very different values from the rest of the country. The rhetoric, which I don't know how many of you have been used to, or have you been noticing the concept of transformative constitutionalism, of using the constitution as a tool to transform the people, is basically coming out of that idea. While, on the other hand, I personally contribute to the concept of something which is called cultural constitutionalism. Constitution which arises from the culture of the people. Now, the archetype, I think the best illustration of the judgment is of this discussion is Sabarimala. In Sabarimala, there were two judgments. The majority judgment believed that you have to transform people to make them something akin to the values. You transform the rest of the country to values akin to what, enlightened, within inverted commas, people hold. While cultural constitutionalism, that's the dissent in that judgment, spoke that we should have a consensus and that the values of the people are reflected in the Constitution. And the Constitution should be interpreted in a manner which keeps in consonance with the values of the people. Now, the question, as I said, going back to what you just flag marked and what I flagged at the end of it, the danger what we now see, and this is irrespective of what has happened in the past, the danger what we now see is the tendency of trying to make the people whom we think are the great unwashed, whom we think, to make them more akin like us and force our values, or enlightened, or in some ways westernized values on them. That's the tricky part. And this is not only happening in India, this is a globalized fight as to whether the values of a technocratic elite will be pushed down on the majority of people of the world, or people in accordance with their own culture will have their values and will be entitled to govern themselves, and therefore their constitutions will reflect their values. This is a globalized fight, and this is a globalized fight. This is not a values which is, restricted only to India. It's happening everywhere. And, as they famously say, now the future of the world, the politics are between the globalists and the patriots. So it's the choice, and I think that's also reflected in constitutional law.
So, due to paucity of time, I just have a small question from Malika ma'am. Our constitution is a living document, and there is ample power in the constitution itself, which can be amended, keeping tab on what is happening in the society. So, don't you think that there is no need of entering into this arena by the judiciary?
I'm so glad you asked this question because the only point when I spoke just a few minutes ago, I had not focused on were the golden triangle of 14, 19, and 21, the three articles. Now, for that, I would answer your question straight away by saying, and these are not really words which are coming from me, but these are words which have traveled from 1950 till today. And therefore, I am saying, and I have complete faith in that the protection of these three articles for our citizens, and we have seen that infraction has happened in the past, is what actually takes our country into the realm of a welfare state, a progressive state, and a successful state. And where we have to control any kind of infraction of these rights, that is where the role of the judiciary is very important, along with a healthy balance of power of the parliament. Thank you.
Thank you very much, panelists, for your positive views and for this insightful session. Moving further, before we move further, I would request Mr. Harshad Gupta to felicitate Senior Advocate Dinesh Goswami, sir. I would request Megha Sharma to felicitate National President Adhivikta Parishad Srinivas Murthy ji. And lastly, Mr. Vikrant Goyal to felicitate Hari Boinkar ji. I hope you all enjoyed today's session as much as I enjoyed hosting it for all of you. And to present the vote of thanks, ladies and gentlemen, I would like to invite on stage Vikrant N. Goyal, Advocate and Vice President, Young Advocates.
No one who achieves success does without the help of others. With the wise and the confident acknowledge the help with gratitude. With this quote of Alfred North withheld, I, Advocate Vikrant N. Goyal, stand before the wonderful audience. I extend my warm greetings to the wonderful audience. I would start my vote of thanks by extending my due regards to guest of honor Shri Bhupender Yadav, Honorable Union Cabinet Minister, Shri R. Venkatramani, Honorable Attorney General of India, Shri Mahesh Jethmalani, Honorable MP Rajya Sabha, Dr. Anirban Ganguly, Honorable Director, Dr. Shama Prasad Mukherjee, Research and Foundation, Dr. Suyash Pandey, Y20 Track Chair and Advocate, Supreme Court of India. I would also like to extend my gratitude to Mr. Mohit Mathur, Senior Advocate and President, Delhi High Court, Mr. Jayant Mehta, Senior Advocate, Ms. Priya Hingorani, Senior Advocate and former Vice President, Supreme Court Bar Association, Mr. Apur Kurup, Advocate on record. I would also like to extend my regards to Mr. Vikramjit Banerjee, Additional Solicitor General of India and Senior Advocate, Mr. Garima Prasad, Senior Advocate and Additional Advocate General UP, Ms. Malvika Trivedi, Senior Advocate. Finally, I would like to extend my warm regards to the Executive Committee of Young Advocates. I would also like to, lastly but not the least, I would like to extend my regards to Y20, G20, Shama Prasad Mukherjee Foundation, Lawyers Voice for extending their helping hands. Thank you.
Thank you so much, sir. I would now request our respected panelists to respect and sing along our national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय
Request everyone to join us for the high tea.
Request everyone to join us for the high tea below.